So in this context, the object of water rights is to improve water management on land and to use this scarce resource on a sustainable basis without jeopardizing the needs of future generations. I'm going to go through just a brief history of how water rights have evolved in our country. And there are four basic broad periods. We speak of the pre-colonial or African customary rule period, when customary law prevailed. There was the Dutch East India Company rule period from 1652 to 1810. And then the colonial period under British and then apartheid rule from 1810 to 1990. And finally, the current democratic rule from the 1990s to the present. There are essentially four legal doctrines that pertain to water rights. The first is called dominus fluminis, or the owner of the river principle. And in other words, the absolute ownership of water is by the governing party. And in this case, that's the principle that the Dutch adopted in the early years. There's the riparian rights doctrine, and that's the right to the use of water resides in the owner of the riparian land, or the land along the water courses. And that's very much from the British rule period. And then across the globe, there's the appropriation Colorado doctrine from the US. And in terms of that, rights are given to those who claim it first. They talk about first in time and a first in right principle. And finally, the correlative rights, or the California doctrine, also from the US, which combines riparian and appropriation doctrines. So it's important to note that under all four doctrines, water rights are usufructuary. That is, a person obtains the right to use the water and not to own it.